Good morning, everyone. I am David Marciano, attorney at Brown, G. & Wenger Law Firm, member of the Contra Costa County Bar Association Board of Directors, and board liaison to the CCCBA Appellate Section. On behalf of the Contra Costa County Bar Association, I would like to welcome you to the 26th Annual MCLE Spectacular in this morning's program. The Supreme said that, a review of recent California Supreme Court cases impacting civil litigators, presented by the CCCBA Appellate Section. Sponsoring the session today is Hanson Bridgett LLP. Hanson Bridgett is a law firm with more than 170 attorneys and offices in San Francisco, Sacramento, the North Bay, the East Bay, and Los Angeles. The firm is driven by a commitment to diversity, charitable giving, pro bono legal work, and hands-on service. Thank you to Hanson Bridgett for your sponsorship of this annual event and continued support of CCCBA. Please stick around after this program to hear from one of our keynote speakers, Congressman Eric Swalwell, who represents Southern Contra Costa County and Eastern Alameda County. Please also visit our sponsors and stop by the section meeting rooms. As a reminder, all programs from the MCLE Spectacular will be available to watch next week on this platform until the end of the year. Our event and program sponsors are a very important part of our CCCBA community. They make it possible for us to provide events like this. Please support us by supporting them. I would like to again thank Hanson Bridgett for sponsoring this session. At this time, I would like to pass the program over to Gary Watt of Hanson Bridgett, and chair of the CCCBA Appellate Section.
Thank you, David, and thank you everybody for joining us today for the 2020 MCLE Spectacular. It's great to be here, and I know it's an adjustment for everybody, and we appreciate all of you attending. We hope to present to you today about a dozen California Supreme Court cases, and within each one to find some wider applicability that may affect more than just what's going on in the individual cases. I'm very pleased to have with me today to present for a second year in a row, Justice Peter Siggins of the First District Court of Appeal, the presiding justice of Division 3 in San Francisco. Justice Siggins has a long history of public service on the Court of Appeal and also up in Sacramento, and always provides us with some tremendous insights into the judicial thinking about how these cases are decided. And I'm also happy to welcome back for what must be probably the 10th, 11th, 12th year in a row here for these programs, Don Willenburg, the National Practice Chair for the Appellate Practice Group at Gordon and Rees. Don has a wide array of appellate cases and appellate practices, and his cases really run the gamut. He's a thought leader in all issues appellate, and I'm so happy to be able to work with him a couple times a year, and this is one of them. So we'll get started. We'll start with the first of about 11 cases we want to talk about today, and Don is going to take the lead on this one.
Thank you, Gary. Well, the first case we're going to talk about is something that is not within my wide array of experience, and probably not within yours. We're going to start this program with a case about a conservatorship, something that's an area that people mostly don't know much about, that's governed by all kinds of very specific and abstruse statutes. But we're going to show you how this really does have something to do with your civil practice. The other big issue in this particular case, in conservatorship of OB, is the proper appellate standard of review, which to some people ranks either just above or just below conservatorships in their area of focus or interest. But again, I hope to show you how this case actually is going to, or may impact your civil practice. In conservatorship of OB, there was a petition to appoint a limited conservatorship for a young woman with autism. The petition was granted. She opposed the petition, and said, well, it didn't meet the standard of proof required for a conservatorship. that standard of proof is clear and convincing evidence. We may be familiar as civil practitioners with clear and convincing evidence for such things as punitive damages. It ought to be something other than a preponderance of the evidence, which is all you need for most civil questions. But of course, it's something less than the criminal standard of beyond a reasonable doubt. So she loses the petition, she appeals, and the Court of Appeal applied the ordinary appellate standard of review on review of a factual determination, and that's called substantial evidence. A standard that is about as misnamed as anything in the law, because it doesn't mean evidence that's really substantial. It means any evidence that you could possibly consider to be substantial. It is a very, very favorable standard of review towards affirmance. Whereas you might say to yourself, but the clear and convincing standard, well, that's kind of goes the other way. There was a split of authority between what happens when you take an issue that must be decided by clear and convincing evidence up on appeal. Some courts said, well, that means that the appellate court has to determine whether or not the evidence was clear and convincing. Other courts said, no, the clear and convincing standard disappears on appellate review. And you just look at it from the substantial evidence point of view. The Supreme Court said, no, clear and convincing evidence means clear and convincing evidence at every step along the way, so that if something had to be proven by clear and convincing evidence at the trial court, the Court of Appeal doesn't just decide, is there any evidence or the substantial evidence supporting the decision. The Court of Appeal has to look at it from to determine, was this clear and convincing evidence? Now, one of the most astonishing things about this case is that it quotes Witkin extensively, and I may be showing my age, but to me, Witkin is still is really the gold standard of interpreting California law. I won't diss anybody else, but Witkin's the standard. And the case quotes Witkin, and Witkin recites the cases that say the clear and convincing standard disappears on review, and it rejects that. I'm kind of shaken that Witkin has been reversed, but in this case, I think it does make sense, and that ought to be the rule. It is the proper rule. Now, how might this affect a civil practitioner in another case? Assuming you aren't, clearly if you have conservatorship cases, then you know what this is about, but conceivably, it should also apply to even what the trial court does. And I can give examples of this, and I'll go back to punitive damages. I'm sure other defense lawyers have had my experience where you say, judge, that yeah, they have some evidence, but it isn't possibly clear and convincing. And a trial judge says, well, you know, it doesn't convince me either, but a jury could come to that conclusion. And that's just not the right standard, even at the trial court level. The trial judge should be saying, would this be enough? For example, you know, you might, what is really the difference here? Well, if you have testimony of one witness and you have to come up with a couple of inferences from that to support a particular point, well, that might be enough on preponderance of the evidence or substantial evidence review, but it might not be enough for clear and convincing. This case has been applied in at least one other appellate decision already. I have not seen it effectively applied at the trial court level, but I urge you, if you are dealing with a clear and convincing standard of proof on either punitive damages or something else, go ahead and take a look at this case and cite it to your trial judge.
Well, Don, maybe I could just maybe talk about what the gray area that this really that remains here. So to put it bluntly, if you're the appellant and you've lost at trial, and your contention is there's no way this should have happened, and it's all about the lack of evidence and so on. Well, then when you go up on appeal, you face the dreaded substantial evidence standard. When the Court of Appeal reviews the case, if it finds any evidence to support the verdict, that's called substantial, and you, the appellant, lose your case. And many of you have probably faced this scenario before and know that the substantial evidence is bad for appellant. What's interesting to me about this case, and I'd like to get Justice Siggins' thoughts on it in a moment from the appellate perspective, is that the High Court defines the test as looking at the record as a whole and determining whether the record as a whole contains substantial evidence, there's that word again, substantial evidence from which a reasonable fact finder could have found it highly probable that the fact was true. So is this a hybrid substantial evidence test? And then how does one determine, how does one know when something is highly probable? And for me as an appellate lawyer, that just opened a door. Because my highly probable and Don's highly probable and Justice Siggins' highly probable, where is that line? So there was some beauty, there was some clarity before in the appellate courts that have been rejected. They said when you go up on appeal on clear and convincing evidence, you just do what you've always done. You look for substantial evidence, and if you find it, then you affirm. The appeal is rejected. But now it's one step further. You go and find the substantial evidence, and now you have another role. Is this enough that made it highly probable? What is that highly probable? What does Witkin have to say about highly probable? But instead of asking Mr. Witkin, I'll ask Justice Siggins.
Well, Gary, thank you. I'm not entirely sure what highly probable is, and partially the reason why I'm going to say that is because the opinion also makes clear that just like you would with a substantial evidence case, you construe the record in the light most favorably towards the judgment. Well, if we're going to construe evidence in the light most favorably towards the judgment, it's a very, very fine distinction that I think the court's trying to draw here. And it's one that judges may be able to make. I would say that, you know, the first thing I'm going to look at when I get a case like this is, was there a motion for a new trial, and what happened in the motion for new trial? You know, how did the trial judge feel about the demeanor and the credibility of the people who were there in front of them on the witness stand? And so I think, you know, it's a standard that we've applied. Certainly our division and our court has applied consistently in dependency cases. We see it regularly. The clear and convincing standard applies to parental rights determinations. And so we're somewhat used to that. But seeing it in a jury context is going to be a very different experience for the courts, I think.
I think that the takeaway for some of you who are going to end up being appellants in a case involving punitive damages, in defamation cases where you need actual malice, and other instances, they're out there, they're a bit more rare or esoteric, where the clear and convincing standard applies, is that before, as appellant, when you were facing the substantial evidence standard, you didn't have a lot to work with. Pay attention now on punitive damages and other cases, because this is new law. There's now this highly probable element that has to be met on review, and now there's a little more to work with than there was before.
Yeah, there's a little more, but also think about this. What is the likelihood that this appellant is going to get a different result? The trial judge who was there said it's clear and convincing, and that was with a factual record. That seems particularly difficult to me in a dependency, or perhaps one of, you know, Justice Siggins was talking about some of the other family law areas. Maybe there's more of a chance for that on punitive damages, because I think lots of times, certainly in product cases, that's based on a documentary record. There's not so much weighing of credibility, but in her case, She's still got a real uphill climb.
Well, I think we'll leave it there, maybe on a note that there's new law, and where it's going to take all of us, we're not entirely sure. If it's a small improvement on substantial evidence for appellants, then you got to take what you can get if that's where you are. And Justice Siggins, perhaps we could have you address the next case.
Sure. My first case is St. Francis Memorial Hospital versus the California Department of Public Health. And this is a case that deals with the time limitation in the government code for the challenge to an administrative adjudication. Government Code Section 11523 provides that if you're going to challenge an administrative adjudication, you need to file a petition for writ 30 days from the last day on which reconsideration could be ordered. In this case, the court considered whether the doctrine of equitable tolling can apply to this determination, and if so, how. And the how part is something that I think will have broader application, as we'll get to in a moment. But in this case, St. Francis Hospital was fined $50,000 for leaving a surgical sponge in a patient. The department decision stated, this decision is, quote, effective immediately, close quote. St. Francis indicated to counsel for the Department of Public Health that they were going to file a petition for reconsideration, and they did. And then they said, I believe that we have until January 19th to file a writ. The department counsel comes back to them and says, yeah, I think that's right. In fact, they had no time to file a writ, because when a department decision is effective immediately, there is no opportunity for reconsideration. So because they couldn't file a petition for reconsideration, the time clock started to run. January 26th comes along, St. Francis files their petition. The trial court sustains a demur on the basis that it was time barred, and that their claim of mistake was not a valid excuse, not an adequate excuse. The Court of Appeal affirms and says that the circumstances don't warrant equitable tolling. The California Supreme Court takes the case and they say there are two questions here. Does equitable tolling apply to actions that are filed pursuant to 11523 of the government code? And if so, does it apply here, and what are the elements to apply equitable tolling? And then the opinion goes into a fairly lengthy discussion about the statute and the legislative intent behind it. And it says, hey, this is a 30-day limitation. It's a very short statute. And they compare the statute to the statute of limitations for latent defects for construction cases. And they say, hey, the legislature gave 10 years there. We can understand if equitable tolling doesn't apply if you have 10 years to file something. But here they've only got 30 days. And after doing a statutory analysis, they come to the conclusion that, yeah, equitable tolling does apply. The interesting thing about that discussion for me is that the Court of Appeal and the trial court didn't question that premise. There's nothing in the Court of Appeal opinion that says it doesn't apply. The Court of Appeal, in fact, goes through the analysis to determine whether it was appropriate in that circumstance. So then the court goes on and it says, the doctrine has three elements. And the three elements are timely notice that you're going to petition, essentially, lack of prejudice to the defendant, and then reasonable and good faith conduct on the part of the plaintiff. And this third element is where the court is being a little bit different and a little bit more expositive than it has been before. Another thing that I thought was kind of interesting is right after Justice Cuellar, who wrote the opinion, lays out the test, he says mistake or neglect alone doesn't include a late filing, but neither is it dispositive. For me, neglect is a word of import. And I can understand excusable neglect. I can understand mistake, but neglect is a different thing. And lawyers are always wary about neglecting obligations. And I think you should remain wary about that. And he says, okay, the first element, that's clearly fulfilled because St. Francis notified the Department of Public Health they were going to do this. They were going to tackle it. So no problem there. Nor is there prejudice here. And he analyzes prejudice from the point that the Department of Public Health was not impaired in defending against this writ. the Department of Public Health said, hey, there's always prejudice because we have an interest in finality. And Cuellar's opinion says, no, that's not enough. We're talking about, are you going to be able to put on a defense, and have you been prejudiced or compromised in your ability to do that? And then he says, well, but I can't tell on this record whether the third element is fulfilled. And equitable tolling applies only in carefully considered situations to prevent unjust technical forfeitures. Now, you know, after some 20-something years, 25 years of practicing law and 15 years on the Court of Appeal, technical forfeitures of causes of action, in my experience, happen all the time because deadlines have always had significance. But so what he says is, look, we're going to remand this back to the Court of Appeal, and there are two things to consider. You have to look at whether the conduct was reasonable and in good faith on the part of the plaintiff for this third element. Reasonableness, and this is more expository than we've seen in other cases. Reasonableness is objective. Do the facts and circumstances around the application of equitable tolling, are they reasonable? And good faith is subjective. Was there subjective good faith on the part of the plaintiff with respect to the excuse, if you will, or the circumstances that made it late? And here's what's kind of interesting about this case to me. He says we can't answer that, and we're going to remand it to the Court of Appeal. But in the Court of Appeal's opinion, the Court of Appeal says we don't question the good faith here. So the question that remains for the Court of Appeal is whether the facts are objectively reasonable. And he's remanded it to a court that can't hear new facts. So I'm not sure what's going to happen. Briefing is not yet filed. I know that they're waiting for briefing in the Court of Appeal. The other thing about this case that I thought was interesting was that St. Francis writes a letter to the Department of Public Health, and they say, hey, we understand that we have till January 19th to file our petition for writ. Department lawyer answers them and says, yeah. Well, they filed January 26th. So even by their own calculation, they were late. And that is a factual circumstance in the opinion that's just not addressed. And the third point that I'd say about this case is that what would happen here if instead of a monetary fine, the department ordered St. Francis Hospital to write a policy or implement a policy, which is what they thought they had to do when the whole proceeding began? Would we still be looking at the doctrine of equitable tolling and considering it on these facts if what we were talking about was a policy that was directed to ensure public safety and public health? And that is my brief synopsis. So I'll let you guys tear me apart.
Well, no tearing apart, Peter, but I guess as sort of a starting point, a takeaway from this case that applies in a broader context.
Yeah.
I think that the starting point perhaps is that there is this presumption, a general presumption that equitable tolling will apply. So that's the starting point. So if you're wondering if you're going to be timely with your action or if you've waited till it's too late, there's a presumption that equitable tolling is available, and that's the starting point. And well, then yeah, go ahead, Don.
And think about that, and particularly the way they talk about it. They say that equitable tolling is, quote, lurking in the background,
yeah,
unquote, of the statutes. And we presume that the legislature knows about it lurking back there because sometimes the legislature says no equitable tolling. Well, lurking in the background sounds an awful lot like statutes and derogation of the common law will be strictly construed or something like that, which is very odd. And if that presumption about what the legislature knows about existing common law were ever true, is it true these days when there are fewer and fewer and fewer lawyers in the legislature?
Well, and here's those are very good points, because I think that the interesting thing about this case for me, Gary, you're right, is that the courts would assume that equitable tolling can apply unless the legislature has somehow indicated that it does not. It's a judicially created doctrine to deal with these time constraints.
And I think that the courts, Peter, the court's use of Lancy is the statute of repose, refers to the statute of repose. It's the most black and white example the court could find. And it's an easy one to say, this is an example where there's no equitable tolling. We know it by reading this statute. But everything else, it's going to resolve on this sort of review of the statute, ambiguity, and now we're going to go to these elements and go ahead and see if we're going to apply it. And now the takeaway seems to be that while there's a more of a sort of discussion in the majority opinion of these elements, there seems to be more wiggle room in these elements now in the way that they've been broken down, or at least more steps involved. And that, to me, gives the courts a chance to go either way.
I think that's absolutely right. And I think that third part of the test that's now been, kind of explained the way it has will lead to, declaration battles with respect to these kinds of motions when they're filed in the trial courts. And I think you're going to see the whole question of subjective good faith be something that, is developed in further cases.
This may not apply to as broad a range of failures as you could think. I mean, again, this one, in this case, they'd already fought about it. There was a proceeding and reconsideration. There was a very short time window. They missed it by just a little bit. When I first looked at this case, I represent public entities. And so I was very concerned about the tort claims claim presentation situation. But most of those would be very different than this one, because the problem in most of those claims presentations is the claimant doesn't get around to telling the public entity that there's any problem until time has gone by or too much time has gone by, which is a very different situation, and I suspect would end up with a different result even under this test. Because there wouldn't have been the same issues of notice or lack of prejudice as you have here.
Yeah, and I think you also had the problem with the public entity lawyer saying, yeah, you say you got till January 19th. Yeah, that's about right. That's something that public entity lawyers have to be careful not to do.
Yeah.
Yeah.
Well, we have another public entity case for our next case, which is National Lawyers Guild of the San Francisco Bay Area chapter versus the city of Hayward. And I call this the redaction is not extraction case. And we'll try to move through this one a little bit more quickly just for time management purposes. But I think I'll say up front that the takeaway from this case, I'll get to the holding in a minute, but I think the broader takeaway is that this is a case that sort of walks through every aspect of statutory interpretation that you've probably ever heard of. And by the time the court gets to the end, it ultimately says redaction is not extraction. But if you've ever wondered all the different ways that you could attack statutory interpretation, this is it. So what happened here was the National Lawyers Guild wanted police body camera footage from events in Berkeley that involved some public demonstrations over civil rights issues. And basically the city of Hayward had the video, but there were parts of the video that were protected by privilege and other things. And so it had to sort of clip the video before it could give the video to National Lawyers Guild. It had to do the electronic equivalent of redacting or removing pieces of the video. And basically, it spent about 40 hours or so on this type of electronic redaction. And then it charged the National Lawyers Guild just short of $3,000 for that work. Now, had these been paper records and had the redaction been done that way, or had they been PDFs where the redaction could be done very simply and quickly, the statutes say you can't charge for a redaction. That's the way the Public Records Act works. But the question here was, what about this provision on extraction and the expenses recoverable for extraction? So the city of Hayward argued, so the National Lawyers Guild got the footage. They filed a petition for writ of mandate challenging the fee. And lo and behold, it goes all the way up to the Supreme Court. The trial court said that the city of Hayward could not charge for this. Extraction is a term of art, and it has to do when a public entity holds a lot of information in a database, and in order, it can't produce a document, but it can produce the data, but it has to take bits and pieces of the data out of the larger database, and that's basically extraction, and that's what the trial court held, and it ruled that the city couldn't charge for this. Well, the city appealed, and the Court of Appeal, including one panelist who's with us here today, reversed and said the city could charge for the redaction, because in this case, that redaction was in fact extraction under the statute. The Supreme Court said no. The Supreme Court rejected the Court of Appeal's reliance on legislative history. And all of these dynamics make this case very interesting to me. But ultimately, in not entirely flattering words, the Supreme Court said to the Court of Appeal and to the city of Hayward that nothing in the record supports the inference involving the legislative history that the Court of Appeal had relied on. We call that an ouch when we're reading the documents, and I'm sure Justice Siggins might have said that out loud. But why don't I let Peter comment on this? What ended up basically is having the California Supreme Court say the legislature did not mean redaction when it said extraction.
Yeah, and I think Justice, the opinion draws a big distinction between electronic records and paper records, right? And it says, look, we've been dealing with paper records for a long time. We know what that means. Extraction, when you're talking about electronic records, is something else. But I will say that the thing about the legislative history that we got slapped for most significantly, I think, was that when we worked up the opinion originally, there was a lot of opposition to a cost allocation provision, or bearing their own costs, for cities and counties to bear their own costs in this area. And when this language was inserted into the bill, all that opposition went away. And we relied on the fact that there was no opposition in the legislative record to indicate that there was some understanding that this would cover the very redaction costs that all these opponents of the bill were concerned about, and apparently not. So the other thing that I would say is that just the opinion addresses Sander versus Superior Court and talks about these records and extraction and compiling a new record, having to compile a new record. And I think it's still a little bit unclear where extraction is just taking something out of a record and where extraction means pulling data out and making a new record. And I think that's a fertile area under this Public Records Act stuff that we'll see more of.
Don, any additions or deletions to that?
I was just thinking Justice Siggins will probably get the chance to revisit this and do it again.
Well, he'll know one part of the legislative history that shouldn't be relied on, at least on that issue.
Yeah, I try not to make the same mistake twice.
We all know what Justice Scalia thought of legislative history, and how he said it's a lot like going to a cocktail party and looking over the heads of all the strangers and looking and looking and looking until you find the one person you know and latching onto that person. And maybe that's what happened here. I don't know, but I think the opinion's a little unkind in the way it describes the use of the legislative history, but we'll move on and we'll go to what I call the case involving a logo, and the theme for this case is a logo hearsay? Is a logo hearsay, or even when is a logo hearsay? So this case is Hart versus Keenan Properties, and it was decided by the California Supreme Court last May. And the facts of the case are basically this. It's an asbestos personal injury case, and in the case, the plaintiff sued for mesothelioma illness, and the principal witness, the events were 44 years ago, as is often the case in asbestos cases, and the principal witness in the case was the foreman back in the day that the plaintiff worked for. And the foreman had a recollection that when they were on the job, he saw invoices on shipments of pipe that were delivered to the job that had a distinctive K logo with a K, and the K was actually designed to show pieces of pipe. So this logo was pieces of pipe arranged in the shape of a K. And the foreman testified over objection that when he was at the job, he thought that there was Keenan pipe there, and he recalled seeing the logo on invoices for pipe delivered to the job with the distinctive K on it. The defendants objected on hearsay grounds, and the trial court overruled the objection. And it overruled it in two ways. The first way the trial court ruled was that it's the testimony about the logo was not offered to prove the truth of any statement, but it was offered as circumstantial evidence linking Keenan pipe to the project in question. And then the second thing that it ruled was that even if it was hearsay or offered as hearsay, the exception for the statement or the admission of a party opponent applied because another witness who worked for Keenan at the time verified that there was such a logo with K in the shape of a pipe at that time on invoices. And then there was the testimony about this invoices. So linking the two together, this made a party admission or an admission of a party opponent. And so the jury returned a $1.6 million verdict, a big verdict really in an asbestos case. You know, of course, the defendants appealed. And the Court of Appeal in a split decision reversed. And their take on it was very different than the trial court's. And what the Court of Appeal sort of hung its hat on for purposes of its ruling was that there was no actual invoice coming into evidence. And because there was no actual invoice coming into evidence, the hearsay exception for the statement of a party opponent couldn't apply, which is interesting because then it's like as if the invoice is making the statement. The invoice is Keenan, and the invoice is making the statement. But that's sort of where they went. And they also said because there was no invoice, there was nothing to authenticate. And with nothing to authenticate, the foreman had no right to testify, oh yeah, that's the one that I saw. That's the invoice that I recall seeing. And so they reversed, saying this actually was hearsay, and the exception for a party opponent admission did not apply. So it goes up to the Supreme Court, and the Supreme Court actually reverses and says the trial court got it right. And I think that the best example, the court, whether it's satisfactory to you or not, the example is pretty clear, as the hypotheticals are always easy, right? And the Supreme Court says, what if the Keenan invoice at the time said, Keenan, the best pipes in the world? And the foreman recollected seeing the best pipes in the world. I saw pipe shipments, I saw invoices, I saw the best pipes in the world on those invoices. That must have been Keenan. And the court says it's not being offered to prove they are the best pipes in the world. It's being offered as circumstantial evidence that Keenan pipes were associated with that project at that time. And so it should have come in, and it reverses the Court of Appeal and affirms the $1.6 million judgment. So here's my take on it, and I'll turn it over to the others, right? The trial judge gets it one way. Two members of the Court of Appeal say that's wrong. A dissenting justice, but for different reasons in the Court of Appeal, says it's right and we shouldn't reverse. So we have four jurors in black robes in complete disagreement about how the evidence code works. And the Supreme Court comes in and in a unanimous opinion tells them, this is really easy stuff.
Go ahead, Don. Do you want to, I will say one thing that's real quick is really quickly about the missing invoice in the testimony. The Supreme Court deals with that with kind of a slap of the hand and says, hey, it's testimony about a lost document under 1523. It comes in. Of course it comes in. It's not a problem. You can prove the contents of a lost document. And the other thing I'll say is that this is a Corrigan opinion. And when you read this opinion, you hear Corrigan talking to you. The other hypothetical that precedes the one that Gary just mentioned is a classic Corrigan hypothetical. A calls B stupid. You don't allow the statement that A called B stupid in to show that B is stupid. You allow the statement in to show why B might have assaulted A. And she says, this is kind of no different than that. So it's really, I think you're right. They essentially took something that I think a lot of reasonable judges disagree on and said, oh, no, real straightforward.
It's very easy. It's very easy.
When you're the Supreme Court.
Since we have a couple of hearsay issues, I went to a grand old source here, Irving Younger's An Irreverent Introduction to Hearsay. And he points out that there are an infinity of possible relevances. Only one theory of relevance out of that infinity will make it hearsay. So in some ways, if you can't figure that out, you're the one who's stupid. Well, just to borrow Justice Corrigan's point. But we say it's offered for another purpose. And of course, we'll tell the jury that. Well, you know, the Supreme Court has in other situations said, we can't tell the jury, it's hearsay, don't accept it for the truth. We're going to talk, the Supreme Court did that in People versus Sanchez, and we're going to talk about that in another case later today. The Supreme Court said it's a fiction to believe the jury will draw that distinction. Well, so isn't it also then a fiction to believe that the jury will not draw from this statement the truth that this pipe company was on site? This was not, however, as Gary alluded to, the only piece of evidence in the case. And I think that's something that was also significant. You did have a foreman who testified to it, and it was in fact distinctive. The court even puts the graphic in a footnote, which is an unusual but interesting thing. And the court also emphasizes, well, this is, you know, it's also a matter of discretion. So I don't know if Justice Corrigan would have gone the other way, had the trial court ruled the other way or not. At the oral argument on this, defense counsel made a big point and said, well, you know, he's just talking about this and there's no document and evidence and he could be just making it up. Justice Corrigan, who I guess I should have known then was going to write the opinion, said, yeah, people lie. We get that.
That's what the weight of the evidence is for, right? That's what credibility. Well, let's see if we can leave it here. I've thought about this case a lot, and I'm troubled by the document issue. And what if the foreman had just remembered frequently seeing a truck drive up with pipe on it and the logo on the door of the truck, right? Would he be able to testify? It's his observation. He saw a truck, it had a distinctive logo, and there's the pipe, right? So I leave you with that one. And then one more. What if there was no logo on the truck and the driver got out every time and said, hey, buddy, here's your Keenan pipe, right? Now that's different, right? Now we're all thinking, oh boy, that's hearsay. That driver's not in court. So, you know, I often wish I had a hotline just to call Justice Mark Simons and ask him to help me with my evidence problems. But I will leave it all with you to struggle with evidence, which Mark says is a good thing. And we'll move on to the next case, which is Peter's case.
Yeah, and I do have a hotline to Justice Simons, so I can call him.
Lucky you.
I'm going to try to be really quick with this one. Kim versus Raines. You know, we've seen it before. We're seeing a lot of these cases come out. This is once again the interplay between wage and hour violation claims under the Labor Code and the Private Attorney General Act, PAGA, right? The court considered here whether an employee loses standing when they've settled their individual labor code violations to continue to pursue a PAGA claim. And the answer to that is no. And the way the court gets there is they repeat the already, I think, pretty firm distinction that, look, PAGA claims are claims that are brought on behalf of the state. They're kind of like a key TAM action. They're not individual actions. They're not like class actions. And they say here what happened was the plaintiff, there's an arbitration provision, it's a standard fact scenario that we see in all these cases. Arbitration provision, the plaintiff's individual claims are ordered to arbitration, class claims are dismissed, the PAGA action is stayed before the Superior Court, plaintiff settles the individual claims. All that's remaining is the PAGA claim before the Superior Court. The defendants come in and they move for summary judgment and they say, it has to go. He's not injured anymore. We've satisfied these issues. The Supreme Court it draws the distinction between the PAGA claim and the individual action under the Labor Code. And then they look at the statutory language in the Private Attorney General's Act. And they say not every private citizen has standing to bring a PAGA claim, only an aggrieved employee. And an aggrieved employee is defined statutorily as a person employed by the violator and against whom one or more violations was committed. It doesn't say anything about a temporal requirement that you have to have, you have to remain injured. It doesn't say anything about, you don't have standing once you've settled your private claims. Here, the plaintiff remains an aggrieved employee under the statute. There's only two requirements: employed by the violator and be a person against whom a violation was committed. And no matter what happened with those private claims, the plaintiff was employed by the violator and had the violations committed against him. Then finally, the defendants say, well, it should be knocked out on claim preclusion principles. The Supreme Court really summarily says, no, our claim preclusion doctrine deals with successive lawsuits. This is one lawsuit. The PAGA claims remain. The PAGA claims can go forward. And they are part of this suit that was not yet resolved. And that in a nutshell and very quickly is Kim versus Rees. So Gary, you have observations about that one?
I don't have a lot to say about that one. I think, it's another variation on standing. And of course, it's really occurring against the backdrop of class action lawsuits and PAGA being the lever or the last limb for a lot of these cases nowadays with the rulings in favor of arbitration and against individual actions and so on. And so PAGA, of course, everybody knows has been sort of the new frontier of try to avoid FAA preemption, try to keep the case going by having a PAGA claim in there. But what's interesting to me is it's another variation on standing, so that makes it potentially applicable. We're told, or we're often told, that standing is something that is almost jurisdictional in nature. And I think you see that in the analysis here. And that's about all I wanted to add. I don't know if Don has anything, and if he doesn't, we have the big case coming.
I have three things, actually. And the first is, so here is the third of our cases. It's just another simple statutory interpretation case, except they interpret it a lot more simply here than in the NLG or the St. Francis cases. Mm-hmm. The second is the employee's lawyer seems a lot smarter than the employer's lawyer to me in this respect. Employer's counsel offered a 998 for only some claims. Why would you do that? He offers a 998 for only some claims, and that means that the employee settles those claims and now has a war chest to go litigate the PAGA claims. I'm not positive, actually, that a 998 and only some claims would work for 998 purposes, but certainly as an offer of settlement, it seems to have put them in a bad place. And the final thing I'd like to mention is the claims preclusion issue. Not because I think there's anything groundbreaking in this decision on it at all, but it did strike me. I see all the time people arguing for law of the case based on something that the trial judge has done earlier in the case, which is akin to saying to this sort of claims preclusion. And no, neither of those have anything to do with what happened in the trial court. That's all. That's what I think about have on Kim versus Rain.
Well, we were talking about hearsay, Don, and now we have People versus Yamata. Maybe you can tell us why you can expound upon the take that you just alluded to a moment ago.
Okay, so we had one case, and then the case that Gary talked about, and well, that's not hearsay. Well, here we're going to have a case where it's clearly hearsay, and we're going to let it in anyway. People versus Yamata is a follow-up to People versus Sanchez, which came down a couple of years ago, which distinguished what expert witnesses can do with hearsay. And as we all know, experts can rely on anything, including hearsay. And in People versus Sanchez, the court said that's all well and good, but we're going to restrict what the expert can do in terms of transmitting that hearsay to the jury. So if it's case-specific hearsay, meaning it's about the facts in this particular case, the expert cannot relate that to the jury. If it's background facts, then with the kind of things that's why an expert has expertise, training, knowledge, experience, well, the expert can relate that. So, for example, the expert can say, well, based on my years of training as a doctor, I know that these symptoms are X, Y, Z, and we don't have to go into what his specific training is. We know that's hearsay, but we let it in because that's part of his expertise. If the doctor has never examined the patient and says, well, but they told me that the patient had these symptoms, so therefore I would come up with this with this opinion. Well, that would be considered inadmissible in Sanchez. Yamata involved something called the Identidrug website. Who knew? And this site had actually been the subject of 2 or 3 prior Court of Appeal decisions that went both ways on whether a criminalist could talk about what the criminalist saw on the Identidrug website. Why do they have this website? Well, I didn't know until these cases came down that a lot of times the police don't test the actual drugs to determine that they're drugs. Instead, they look for what shape pill it is, what it looks like, what the markings are on it, and then they go compare it to this database, the Identidrug website. So in this case too, they didn't actually grind the stuff up and run it through a spectrometer or do chemical analysis on it. Instead, they looked it up on the internet. And when the case was percolating on its way up, I was thinking to myself, if they allow this, they are going to blow a hole in the hearsay rule as big as the internet. Well, that isn't quite what happened here. But in fact, the court did say, no, when an expert goes and looks at this website, that's part of the expert's training. Now, there were some specifics to this that makes this a little different than just going to any website. This website was regularly relied on by police professionals. You had to be in law enforcement to access it. So it had these these additional, I'll say, indicia of reliability, even though that only counts in federal hearsay analysis and not California hearsay analysis, but those things were true. So the court says, no, it is perfectly fine for the criminalist to say, I looked this up on the Identidrug website, and so I know that it was a controlled substance. What does this mean for civil practitioners? Well, it gives us a little bit more leeway if you're trying to get your expert opinion in terms of what the expert can say and can rely on. It will not affect what I've seen as one of the more significant impacts of Sanchez on civil practice, which involves, again, a lot of times doctors and life care planners and economists, all of whom rely on everybody else's testimony to get there. And a lot of them rely on a treating physician's testimony, which isn't, or a treating physician's report. If the treating physician is never examined, well, then that's hearsay and you can't bring it in. It probably won't affect that. I'm not sure if it will affect the other area that I've thought of, but it may as the most, or as a very difficult area in which to apply Sanchez, and that's real estate appraisers. Real estate appraisers go and they look at stuff, and they weren't personally involved in any of those quote unquote comparable sales. They look it up. I presume now everything is on the internet, right? They look it up there. They have to do that. What else would they be doing? But it seems to be that at least a theoretical Sanchez problem.
Well, Don, after Sanchez and before People versus Vimataha, some courts said that with respect to this database, that it was a lot like a sort of, it was case-specific hearsay. It was case-specific hearsay. So the expert couldn't rely on it absent a hearsay exception. But then they said, oh, this is like the widely published resource exception, or the, the Encyclopedia Britannica exception, or the Bible that everybody relies on here. And because it is, then it's an exception to the hearsay rule. And what's interesting about this case is the Supreme Court says, essentially, impliedly says, no, we stay back on the other side of the Sanchez line. This is just background material, so there's no hearsay problem. And as experts traditionally do, this expert can testify about the identity drug database and how he used it and what he saw there. But what I think about, and you mentioned, is what about the appraisers? We've all been waiting for an appraisal case to come down on Sanchez. And you have the appraiser who goes to Zillow or some similar website and now gets their comps from all these things that they see there. Now, when they go to testify about the value, about the case in question, case-specific testimony, do they get to relate everything that they saw? Is it just the same as the identity drug database, or is it different? I'd be interested in any thoughts, or it's just a rhetorical question.
I like the published compilation exception argument actually better, but Justice Siggins?
No, I personally don't think it's different. I mean, I think they're getting, and I think you're right, Don. It's publicly available information. It's information in general. Suppose they just look at, what are houses selling for per square foot in San Francisco right now? Okay, between $8 and $8.50, and some have a balcony and some have a yard, and that's not case-specific information. It's case-specific information when you say, well, this house has a yard that's 1,500 square feet, and because of that, I'm going to, do something and adjust my appraisal. I think that's a different question. But I see this case. When I first saw this case, I thought it was no different than a doctor consulting the PDR or the monograph for a drug to see what the side effects were. Same kind.
I think that is a proper analysis, because we would say if you had the volume at home, the hard copy, you could look it up. Well, why is that any different than this, at least than this particular website?
All right. Well, let's move on, and for those of you following along in the handouts, we're now going to jump to the end of the handout, case number 11, which is Ixchel Pharma versus Biogen. Peter's going to talk about that, and then after Peter finishes and we do that case, we're probably going to have time for one more, and I'd like to have Don address the Barrow-Terran versus Superior Court case, which is pending right now, because that's about use of evidence at trial, again, deposition testimony, and we should get into that because it's widely applicable. Peter, why don't you take us away on Ixchel Pharma?
Sure. So this is a case concerning the standard that applies to analyze whether there has been an actionable inducement of breach of an at-will contract. I mean, that's essentially what's at core here. Ixchel Pharma had an agreement with a company called Forward to develop a drug. They were in the middle of development when Forward pulled out of the agreement. They were allowed to do so under the agreement. It was terminable upon 60 days notice. Forward gives notice, they get out. At the same time that they were working with Ixchel, Forward was negotiating a patent dispute over this same substance with Biogen, and they settled that dispute. And that was the reason they pulled out of the deal with Ixchel. under the settlement agreement, Forward got $1.25 billion, and they gave their licenses to Biogen, and they were required, quote, to terminate any and all existing and not enter into any new contracts or obligations to Ixchel. So Ixchel was specifically called out in the settlement agreement. They were supposed to get out. Ixchel turns around, they sue Biogen in federal court for interfering with the agreement with Forward. And the case gets dismissed and goes to the Ninth Circuit. The Ninth Circuit then certifies a couple of questions to the California Supreme Court. The Supreme Court says, we're going to consider two questions here. One, is a plaintiff required to plead and independently prove a wrongful act in order to state a claim for tortious interference with a contract that's terminable at will, right? Do you have to plead it, ultimately prove it, that there was some independently wrongful thing that was done to establish tortious interference with an at-will contract? And then the second relates to the standard to determine whether Business and Professions Code 16600 voids a contract when a business is restrained from engaging in its lawful trade. 16600 is a really short statute. It basically says every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void. It seems like a flat out prohibition. We've seen it applied to covenants not to compete. We've seen it applied in an employment context when when an employee leaves a business and then goes to work for a competitor. But what the court does is it first analyzes and it compares the two different torts of interference of performance with a contract and interference with a prospective economic relationship. And it says, look, interference with a binding contract doesn't require independent wrongfulness. It's the interference that's wrong. We want contracts to have significance. We want the parties, including third parties, to rely on them, to know that they're going to be performed. It's important to afford those relationships special legal protection. They've ripened into binding contracts. People should be able to rely on them. But relationships that fall short of a binding contract, they say subsist in a zone where risk and rewards of competition are dominant. And they say this is a different thing. This is generally alleging interference with an informal relationship. In other contexts requires pleading that the defendant committed an independently wrongful act. This is the tort of prospective interference with the prospective economic relationship. And then the court recognizes that contracts that are terminable at will are not like these other legally binding contracts. For example, an independent wrongfulness has always applied to claims of interference with employment contracts. 16600 says, you can't restrain. And if you're going to try to do something about that in an employment context, we look for independently wrongful acts by the defendant. The purpose behind the independent wrongfulness requirement is to strike a balance between providing a remedy for behavior that's really predatory, and then, on the other hand, insulate legitimate competitions from the burdens and the risks of litigation. So they're really trying to strike a commercial balance here. And the court says that, like parties to a prospective economic relationship, those to an at-will contract have no legal assurance that that relationship will continue into the future. So we're going to say that a plaintiff must allege an independently wrongful act to sue over the termination of an at-will contract. Question number one's answered. On the second question, the court then looks to the history of section 16600 and concludes that it's best read not to void all restraints on business dealings, but rather to subject those restraints to a rule of reason analysis. What's reasonable? The history of 16600 and its predecessor, Civil Code 1673, and the cases interpreting them, it goes through a very lengthy historical discussion, says they show two things. One, that agreements not to compete after the termination of employment or sale of a business were invalid without regard to their reasonableness. Whether or not they were reasonable didn't matter. Those were not valid restraints. But agreements that limit commercial dealings and business operations in other ways were generally invalid only if they were unreasonable. And in this context, the court says it's clear that a rule of reason analysis is adopted to determine whether commercial limitations violate section 16600. The rule of reason is a rule that's adopted from the Cartwright Act. The court looks at 16600 and says, hey, the context is right. It's right near the Cartwright Act. The Cartwright Act is in this same chapter. And the applicable standard asks whether an agreement promotes or suppresses competition by examining the circumstances, the details, and the logic of a restraint. So you look at the restraint in context, and on the whole, you have to consider, in light of all these factors, is it going to help competition more than it hurts it? If it helps more than it hurts, it's not a wrongful act. If it hurts more than it helps, it is a wrongful act. There are a number of Cartwright Act cases that apply this standard. The leading one from the California Supreme Court is In Re Cipro. It's a litigation over a restraint on an expiring patent in a drug case. And a very helpful case from the Court of Appeal is a case called Exxon versus Superior Court. They lay out essentially what the rule of reason test is, but the application of the rule of reason is anything but clear. And there are a lot of concepts in antitrust law that I think are going to try to bleed into this. For example, one aspect under the rule of reason is that you don't look to harm just to the competitor. You look to the harm to competition. And is there a broader impact of the wrongful act? And it's not clear to me from reading this opinion whether that concept bleeds over into this tort or not. It may be that harm, trying to destroy this individual competitor is enough, and that's the wrongful act. So I think there will be a lot more development as we move forward into this area, because it's not as clear cut as it may first seem.
So Peter, if there is such a thing as a nutshell for this, before a plaintiff was more focused on what happened to the plaintiff in terms of the actions of defendant. And now the court is saying we have to look beyond that, and we almost have to take the actions of the defendant and see what the impact would be on those in a much broader or larger context. And now, looking at that larger context, it seems like there's a lot of ambiguity about how to make that to make that assessment or that decision.
Yeah, no, I think that's exactly right. I think that what the court is saying essentially is that you look to the injury to competition in general in that relevant market, and you get into issues like, what is the relevant market? How big a player is this defendant? How big of a player is this plaintiff? What was the action designed to do? And I mean, if I were an economist, this might be a full employment act. If I think they just got in every, you usually see these claims in every antitrust case. And,
of course.
And, the antitrust analysis, in my experience, has dominated it. And then the interference with prospective economic advantage kind of follows. But I do think there are going to be some distinctions, and it'll be really interesting to see where they are and where they arise.
And this is another statutory interpretation case, but here we have a whole different way of statutory interpretation. We have a statute that's plain on its face.
Yep.
Except as provided, every contract by which anyone is restrained from engaging in lawful business is void. And what does the court say? The court says, well, it doesn't really mean that. It means that for some cases, they're void, and for other cases, they're not. And the court goes further. And for some of those cases, there's this rule of reason. And the court goes further. How does it justify this complete departure from as clear a language as the legislature could give? It says, oh, well, we've interpreted this to have all this other stuff in it for years, and the legislature hasn't ever called us on it and done anything about, saying, no, that's not what we mean. It may be great policy. It may be great policy, in which case I say, as sometimes justices say to me, write your legislator. Another aspect that strikes me is I'm still not sure what an independently wrongful act is.
Exactly.
If we say it's because, well, the term that it's independently wrongful if it's anti-competitive rather than pro-competitive, well, that allows me to tell some stories, but it doesn't really give me a whole lot of certainty or comfort. I can imagine a situation where someone says, even in a kind of what we would otherwise say is a straight up no violation of 16600. No, you're telling me that I can't compete with you in this area, so that must be anti-competitive. Well, it may be that I, who get that from you, got that agreement to not compete, and therefore stronger, and I can compete better with the rest of the marketplace if I don't have to deal with you in the marketplace. Is that pro-competitive? Is that anti-competitive? Does a fact finder make that choice?
Well, here the federal district court will end up making that choice, and the California Supreme Court doesn't. That's right. But I think the other thing about this is that we look to federal antitrust law to guide our interpretation of the Cartwright Act sometimes. So does that mean that now we're going to have a whole body of federal law that will help inform this area of California tort law? Maybe.
Well, let's leave it there. And Don, for our last case, we have a couple of others on our handout that we're not going to be able to get to. But Don, why don't you give us your take on a case that's pending right now in the California Supreme Court involving the use of deposition testimony at trial?
It's a preview of coming attractions, the Barrow-Tarrant versus Ford case. And the law to date in California has been that you don't get to use a deposition from another case. In your case, even under the prior testimony examples. And the rationale for that is found in a decision called Waldron. And that is, well, depositions are taken for purposes of discovery. And if it's your friendly witness, right, your PMQ, your CEO, well, the other side's going to take that deposition for discovery, but you have no incentive to ask questions. And if there are any defense lawyers out there in the audience, ask yourself, when was the last time you questioned your own witness at deposition? If this case comes down, affirms the Court of Appeal, you might start doing that. This case held that, in fact, if the witness is unavailable, then you can use that witness's testimony at trial just under the standard unavailable witness exceptions to the hearsay rule. What does this mean? Well, as a defense lawyer, I'll point out that this is sort of a one-sided rule because it's corporate witnesses who are going to be testifying in multiple cases, whether it's a product liability or a telephone solicitation or something like that. Plaintiffs seldom are deposed in multiple cases. And if they are the plaintiff, you have another way to be able to get that information too, rather than just another witness. One way in which I'm sure what we will see if Barrow-Tarrant again is affirmed is the tradition people are talking about using reptile tactics in depositions and really trying to press corporate witnesses on issues about, well, don't you think everybody should be as safe as they could possibly be? And if they ever get testimony they like in any case, anywhere in the country, now are they going to be able to play it in your California case? Heretofore, no. After this case, maybe so. Two other things I'll say about this. One is some of the best appellate lawyers in the state who aren't on this panel right now will be arguing this case in the Supreme Court. And now that it's easy enough to get on to the Supreme Court arguments and hear them remotely, I suggest you do when you get the chance on this case. And the other is that it may be that this case doesn't have quite as broad applicability because of the specific facts of this case. It started out as a class action. Depositions were taken in the class action. Plaintiff opted out of the class action to pursue his individual claims based on the exact same facts, based on the exact same supposed problem with the automobiles. So this is a little more understandable. In some ways, it's almost the same action. It isn't really, but maybe even if it's affirmed, it will be affirmed only on these limited facts, but maybe not. And it could mean that you should be cross-examining your own witness at deposition. One of the bases that the court used, and I'll conclude on this, that the Court of Appeal and the trial court used in admitting this evidence was to say, maybe depositions were only taken for discovery purposes 40 years ago when Walgren was decided. But now we always take video depositions. And why do people take video depositions? They take them so they can use them at trial. When Walgren was decided 40 years ago, California didn't even specifically allow video depositions. And now they are fairly de rigueur for apex or key witnesses.
John, maybe Peter, go ahead.
Oh, thanks. I just have a question because when I looked at the appellate opinion, it seemed like unavailability of these witnesses was not contested, that there wasn't any question, but that this dozen people were just unavailable. And it wasn't at all clear to me why. Is that right? Or
I believe that they were unavailable because they're not local. Which again is going to happen in a product liability case where you're suing a national company somewhere else.
But under the code, it's not necessarily unavailable, right?
Not necessarily right.
And Don, one thing I wanted to ask you before we run out of time is, I thought that a driver for limiting the scope of this case was the friendly witness aspect of this, that it's really just an adjunct to well-established law about when you can or cannot use deposition testimony. And now this question about this was a friendly witness. This was the other side's friendly witness in the previous proceedings.
Mm-hmm.
So I get to introduce it now against them in this new proceeding because it was their friendly witness. How is that different than what went on before when trying to use this?
I'll answer a different question than that because I've been seeing people in debates do that a lot lately, and that is it's
just don't call me names.
It's different than a third party witness. At a third party witness deposition, in fact, both sides plainly have all the incentive in the world to ask everything they can. They don't know if they'll ever see him again. They want to find out what this person has to say. Whereas in a friendly witness or your corporate and your person, you don't have that incentive to ask the questions, and historically never have. The practice certainly has been that people don't ask those questions, and they don't. Why does this matter? Because sometimes people because if one side asks questions that beg for an answer, that you would have a response to, you don't want to necessarily do that response in the deposition. You're saving that for trial, right? Yeah. Now you're going to have to figure that out in this case, and arguably you're going to have to anticipate what might happen in some future case.
Yes.
Involving similar issues. And I have to ask questions to guard against that.
In case it comes back and bites me later.
All right.
Right. Well, why don't we leave it there? There is more we could say about these cases. There are a couple more cases that we could have talked about. But on behalf of Justice Siggins and Don Willenburg, I just want to say thanks to everybody for attending today. And I will turn it over to Teresa Hurley.
Great, thank you so much, Gary, Don, and Justice Siggins. This was fantastic, very enlightening. I also want to thank Hanson Bridgett again for their sponsorship of this program. You are now invited to join a live Q&A discussion session with the presenters immediately following these announcements. Below the screen, there is a link where you can click to go to that live Q&A. Materials and evaluation forms for this program can be downloaded from the session page. Just go to the Files tab above the chat. Completed evaluation forms can be sent to Ann Wolf. Your attendance certificates will be available soon. If you're a CCCBA member, they will be in your member profile on our website. If you're a non-member or you want more information, please check out the FAQ tab. Coming up after the break at 12:30 is our keynote with Congressman Eric Swalwell, who will take us to 2021 and beyond as he looks at the latest on the 2020 election and the resulting impact on Congress, the courts, and more. And as a reminder, all of the programs will be available for you to view through the end of this year. All right, now please click on the link below to join the live Q&A session with Justice Siggins, Gary, and Don. I'll see you there.